Hello, everyone. My name is Pilar Martinez. I'm a recent St. Mary's Law School grad, and I currently work at the St. Mary's Immigration Clinic as a clinical fellow. I was also a former staff writer and a former board member of The Scholar, and I'm really proud to be associated with such a great organization. Today, I have the honor of presenting our next panel. So first, I would like to introduce Professor Orange. He started his career as a deputy public defender in Orange County and is now an honored civil rights attorney and advocate who has received several awards, including Top 100 Lawyers in California. He is the director of the University of Southern California's Dornsife Trial Advocacy Program, and today he will be joined by two of his top students and members of the trial advocacy team, Yvette Lopez and Elisa Herrera. Both of these undergrad students have spent a lot of time in Texas at the border working with immigrants. Hopefully they will both go to law school because they will be great attorneys. Help me welcome them to the stage.
Good afternoon, everyone. Greetings from California, one of the homes of the Ninth Circuit. We're very glad to hear, of course, about today's decision. And what we're here to talk about today are some of the fights and some of the techniques in terms of fighting unfairness in court. I've brought with me two of my most magnificent students, of course, Yvette Lopez and Elisa Herrera. They are phenomenal advocates even already, and going forward, I'm sure they will continue to develop and continue to be phenomenal. And we would like to thank Gabriel for inviting us. I don't know, oh, there he is. We met Gabriel at Pro Bar one year when we were down in South Texas doing a lot of work on trying to figure out how to get past certain things in court and make representation a little bit easier in the face of some of the tactics that the government attorneys were employing to really mess things up for clients. And I see some of my friends from Pro Bar in the audience. Glad to see you guys. One of the things that we learned when we went to Harlingen was that in the proceedings, there is a lot to potentially be done with regard to discovery and gang evidence. Gang cases represent a lot of the work that I do in Los Angeles, and we were made to understand that a lot of times the government springs gang accusations and evidence of supposed gang involvement upon you when you're in court representing a client in an immigration case. And so we endeavored to see what we could do about putting together some tactics and techniques to, number one, get good discovery as to what is potentially out there as far as gang evidence, and then number two, what to do with it when you get it. And so that's what we're going to talk about today. The objective, of course, with regard to discovery is ultimately suppression and termination. What we're going to cover as far as the discovery itself is getting it what it looks like, what the weaknesses are in it, and ways to get it. And then, of course, when you get it, what you do with it is you cross-examine, you impeach, and then there are different ways to get an opportunity to cross. And we put that together, and what exactly a cross-examination can look like. There are various sources of authority for all of this. A really great source of authority is 8 U.S.C. 1229 AC2. The most important part of it, highlighted in yellow, the alien shall have access to the alien's visa or other entry document, if any, and any other records and documents, which is generally the most important part of it. What that does is give you a foothold to get a hold of actual discovery. And of course, in fighting a case, the most important thing you can have is notice of what's coming at you, right? Because as far as an opportunity to be heard, you need notice so that you know what it is you need to be heard about, which, are the bedrocks of due process. Another good source, 8 CFR 1240.10a. The court actually has to advise the respondent that he or she will have a reasonable opportunity to examine and object to the evidence against him or her. All of this goes to fundamental aspects of due process and fairness. Now, my own personal favorite, what I call the ruckus, is an opinion out of the Fifth Circuit in 1992, Olabanji, which says that the court squarely holds that the use of affidavits from persons who are not available for cross-examination does not satisfy the constitutional test of fundamental fairness unless the INS first establishes that despite reasonable efforts, it was unable to secure the presence of the witness at the hearing. And then the next favorite part of it I didn't highlight, but it's one of my favorite parts because so often the Fifth Circuit's jurisprudence is a bit different from the Ninth Circuit. And people say things are a bit easier in the Ninth Circuit, and that's generally true, unfortunately, if you look at it one way, fortunately, if you look at it another way. But the court goes on to say specifically that the Ninth and Seventh Circuits both follow this approach or this rule, and no court has ever disavowed it, right? And essentially what they're talking about is the right to confront and cross-examine. And even though the Fifth Circuit's jurisprudence tends to differ substantially from the Ninth Circuit's, the Fifth Circuit here endorses explicitly the Ninth Circuit's approach when it comes to the right to confront and cross-examine, and gives a wonderful rule to allow folks to get cross-examination. So in a discovery context, why is Olabanji so important? It only requires imagining a simple scene. You're in court, you see some records or reports for the first time at a first hearing. In that instance, what happens if you decline to concede anything? No concessions. Make a list of every witness who filled out a report, and of course there's the special I-213 step. The I-213 has to have, in order for you to call someone in to cross-examine about it, an inconsistency, right? An inherent inconsistency on its face. It has to be some evidence of unreliability for you to call someone in to then question them about it. Most of the time, that's not difficult as far as establishing something, anything that's inconsistent about it on its face. And then you request to cross-examine each one of those witnesses. What should happen is someone should have to start giving you some stuff in advance as far as material and conferring with you as to which witnesses to bring to hearings, and that someone should be the government attorney. And from what we saw in the hearings that we observed, the government attorney will likely not have the slightest idea what to do to make that happen. It seemed to us that they rely in large part upon the judges, and the judges pretty much act as a crutch for them as far as getting things done. So in doing all this, there are some considerations, of course. First one is how will a continuance to obtain discovery, because that's usually what's going to be required if indeed there's going to be discovery given. How will a continuance to obtain discovery impact your client? Is it going to be to your client's benefit, to your client's detriment? What is going to be the resulting circumstance in the interim? Of course, always fully explain to the client and ask the client about it. How will having the witness present impact your case? A little later on in the presentation, we'll see a cross-examination of a Border Patrol officer, and it'll be clear from that cross-examination that having the witness present benefited the client's case, but sometimes it could be a detriment. And what long-term measures need to be in place to maximize the benefit of the ruckus that you create by getting a hold of some discovery that you can actually do some investigation on to represent a client before the client or as the client's case is coming before the court. So, gang evidence. Most of the time, gang evidence consists of conclusory secondhand statements. And the reason that gang evidence, even though it consists of conclusory secondhand statements, is able to have the impact that it has, not only in immigration cases, but also in non-immigration cases, is because in many states, people fear their children, right? It's an unfortunate fact, but it's true. People fear children. In California, for example, California has some of the most ridiculously harsh juvenile laws in the country. As a matter of fact, the gang case that we did recently that destroyed a lot of what Los Angeles was doing to kids was able to work only because we were able to get up under a lot of the preconceived notions that people have when using the word gang. Gang sparks fear. If you hear gang, generally the case goes against the kid, no matter what kind of case it is, right? And so the thing is that when you start to get under the label and you start to try to look at the facts, why someone has been labeled a gang member, usually what you find is nothing that's supportable, right? And so the key is to get up under the label and see if there's anything to support it. So here is an example of a report out of Boston. And in Boston, they say that the Boston intelligence and gang units have determined so-and-so person to be a verified and active member of the Blood Street Gang in the Boston metro area. The Blood Street Gang is among the largest and most violent street gangs in the United States. And then they go on to say the person has documented associations with known gang members and has been documented in violent weapons-related altercations with MS-13, the LKs, and the Somerville Police Department. But what does it mean to be verified? Verified how? Who verified it? What is the method of verification? Where is the file of documents that confirms that somebody is verified? What does it mean to be active, other than the point that it's in capital letters here in the statement? What is that? Active, how so? And what is a documented association, or better yet, a known Bloods gang member? Known to who? Known to the police? Known to the person who's the subject of the investigation? Known to the people who are the supposed gang members? That issue of known to whom, actually, is a big issue in California law. And for at least 20 years, this issue of a known gang member persisted, with kids getting arrested and jailed for being in the company of known gang members, with no one ever asking, known to whom? Does the kid have to know? Do the police have to know? Or do the other guys have to know? Who has to know, right? And so eventually, when people started asking that question, what they found out was there was nothing behind the known to whom part. No one could establish that anyone knew. Half the time, the police didn't know. Half the time, the guys who were supposed to be in the gang, who were the other guys, nobody knew them to be gang members. And almost all the time, the person who it was supposed to be known to certainly didn't know, right? So you've got to start to get up under that. And the only way to get up under it is to get a hold of the actual documents. So this is, in Los Angeles, what they call an FI card. FI is short for field interview. And what the police do is they approach young black and brown men on the street in low-income neighborhoods, and they pull out one of these cards and just start interviewing them. And they ask you all these questions that you're supposed to answer. And then what they do with this information is they put it in a database, and they start to track how many of these different contacts they have with you where you're doing a thing that you're not supposed to be doing based on a court order, which they call a gang injunction. And in this case, what the gang injunction said is that if you live in a certain neighborhood, and of course, the certain neighborhood for all the gang injunctions was some black or brown neighborhood in Los Angeles. So almost all of Los Angeles was under these gang injunctions. But if you live in a certain neighborhood, then you cannot come out of your house from sundown to sunup, okay? It's a curfew, a broad blanket curfew. And as long as they had given you one of these FI cards and handed you the court order, no matter what you did, if you came out of your house between sundown and sunup in that neighborhood, you were getting arrested. Never having had an opportunity to go to court and challenge the order, your first opportunity to be heard in front of a judge was at arraignment. After they've already busted you, you've been in jail for God knows how long, and you've lost your job, right? Or you failed out in school, because a lot of these folks who were arrested are kids. So this FI card is from a young man named Chris Rodriguez. Chris Rodriguez was a client of mine who decided that he was going to fight the gang injunction curfew because he did not want his little brothers and sisters who lived in his neighborhood to ever have to deal with anything like this. And so if you look at this card, it has his identifying information, a description of him. The most important part, so that officers can understand and identify him if they see him again, is supposed to be personal oddities, right? And if you look at the personal oddities part of it, you'll see it listed that his personal oddity is a dark complexion. Now, when I took this officer's deposition, I had a bone to pick with him because I have a dark complexion. And, you know, Chris happened to have big ears, a small nose, and so I'm asking him all these questions about Chris's ears. But this is what the officers write. In order to establish and identify and distinguish a young man who happened to be a straight A student. He was a straight A student in high school, and his grades were so good that he had a housing authority scholarship to go to college while he was in high school. And they bust him when he's coming home from a friend's house doing homework, and this is what they do to him, okay? And so then what happens to Chris is Chris can't leave the house between sundown and sunup. So he decided to fight it. Oops. Oh, here we go. Okay, so they bust him again. Notice, same personal oddity, this time different year, different officer. Oddly enough, it's the same handwriting for dark complexion, okay? And this time, as opposed to the last one, where for moniker or alias, and that's supposed to be like your gang name, like Little Puppet or something from American Me. His gang name in the last one was Chris. Okay, so when the officer puts him in the database as having a moniker because he's identified as this shot caller gang member person, his name is Chris, that's his moniker. Again, his name is Chris, but this time they have /Pinto, okay? And that's a great name for a gang member in LA. But this is the type of information that underlies these designations as gang members. This is what you want to get a hold of by way of discovery methods that we're going to talk about in a second, so that you can challenge. You want to bring Officer Gomez in to ask him about his identification and designation of Chris as a gang member because he had a dark complexion and his moniker is Chris/Pinto, right? And he says documented. Well, documented, what does that refer to? And then oddly enough, this one is from 6/20/2009. This is from 12/7/2013. Here he's not documented. It's all of these inconsistencies when you bring the officers in and cross-examine them. If you can get a hold of this kind of information, and it's out there, so that you can then bring them in allows you to question the credibility of the designation. And to the extent you can question the credibility of the designation effectively, then you can undermine the consequence that the designation has. I'm going to pass to my student, Elisa Herrera, to talk about the next few slides.
When you get into court and they're bringing evidence claiming that your client, the person that you're defending, is a gang member, the reason that you have to question it is because cops lie. Cops lie. And just in the context of this presentation, there were two main reasons that I wanted to talk about. The first is that a lot of the time, especially in Los Angeles, police have quotas. So, they've got to take a certain number of people in, make a certain number of traffic stops, find a certain number of people who are so-called gang members and log them in. And so they lie. And the larger reason for that is systemic bias, that police are disproportionately put in low-income neighborhoods of color, that they're disproportionately believing that young men of color are problems and that they must belong to gangs because of where they live, what they're wearing, and ultimately who they are. And a lot of the time, these assumptions that the police make about who these kids are ends up being treated like a fact. It ends up in court being treated like a fact, and that's the reason that we have to challenge it. Now, in 2020 in Los Angeles, this finally really started coming to light with the FI card scandal, or field identification card scandal. But it's been happening for a long time. It happened to Chris Rodriguez in the early and mid-2000s, and now they're finally starting to have some accountability for the officers responsible for treating children in this manner. So this story starts the way that a lot of good stories do, with a mother who would not take no for an answer. What happened was that this young man, one of many young men of color in Los Angeles who are stopped and profiled by the police, was interviewed, noted on an FI card as a gang member, and entered into a gang database in the city of Los Angeles. His mother found out, wrote a letter to the sergeant basically saying, "What is this? There's a problem here, we need to look into it." The sergeant listened to her. What the sergeant found was that the officers had been falsifying these identification cards, entering information that people had not given them during the interviews, entering evidence that didn't demonstrate any sort of gang affiliation among these kids. And as of right now, over 20 officers right now are being held responsible for those actions. Officers have been disciplined, they have been fired, and we need to keep challenging that evidence and making sure that it doesn't make its way into our court systems and into immigration court as fact when it's nothing more than an assumption.
Good afternoon. So I'm going to be talking about what it looks like when the opposing side is trying to gather gang evidence to establish if your client is deportable. So the BIA has actually adopted California's approach when determining if someone has committed a crime for a benefit of a gang. So questions that we need to ask are, was the migrant's conduct, does it actually establish a conviction? Did they actually commit a crime? Or were they just walking outside at night wearing red shoes and got stopped by a police officer? The second question is, was the crime committed for the benefit of a gang? because even gang members committing crimes aren't always committing crimes for the benefit of a gang. So then that brings into question of moral turpitude. The third question is it really a gang? Or is it just a group of people that are hanging out at night? Or at the daytime, honestly. Like, police officers and sometimes even just other people are so quick to label a group of people as a gang when it's convenient. And many times they apply that label without actually checking to see if it really is. And the last question is whether or not the client's affiliation is just a passive one. Like, they claim to be a part of the gang because it offers them protection, it means that they're protected from being harassed, but they don't take any active measures to further the cause of said gang. So if the answer to, could you go back? Thank you. So if the answer to any of the first three questions are no, or the answer to your fourth question is yes, then it's not a crime committed for the benefit of a gang. And that means that you have an argument that it's not a crime of moral turpitude and that your client may not be deportable. Now for the next one. Thank you. And this is where we get to talk about databases. So I love databases. I'm a computer science major, and integration of technology into parts of our society is usually a good thing, right? More efficiency, hopefully things get better, except that it's not. When it comes to databases, when establishing if someone is a gang member, there are a lot of questions that we need to consider. How is this data being entered? Is the method that this data being collected reliable and trustworthy? Is it based off of interviews? Is it based off of prior convictions? And then the question is how this data being stored reliable? Because we have cases where LAPD uses multiple databases, some external databases, some internal databases, and then the question becomes, what database are they relying on? What databases are they pulling from? When was this data entered? Was it entered accurately? And were there audits? And the audits are extremely important because recently in California, one of our self-proclaimed best and most comprehensive gang databases were audited, and it was determined that the database had inadequate oversight. It had a lack of support for about 23% of all of the entries, and 600 people that were listed in this database were supposed to have a purge date beyond the 5-year limit. There were people listed in this database that had a purge date of over 100 years into the future. So what is going on here? It's important to be able to ask these questions because once we actually get into the root of how the state is obtaining their information, then suddenly you have a case against your client, or for your client, against the state. Thank you.
So the next thing is methods of discovery, right? So you know you need the information. You know what you want to do with the information, but how do you actually get your hands on the information? There are a number of ways to get it. There's a formal request letter with proof of service. You can have a fillable form, or you can use an actual written letter. But in it, whatever you do, please make sure to request specific documents and witnesses and serve it on the government's lawyer ASAP. As soon as you get a hold of the case and have an idea of what you may want, serve it on the government's lawyer. If you have a form request that has types or categories of documents on it, serve that on the government's lawyer. But the key thing is to make sure that you have a provable record of making the request for the information as soon as possible. Because more likely than not, if the court is going to consider any type of discovery issue, the court's going to want you to have pursued the information that you wanted, or at least began to pursue it as soon as possible. Because one of the other things we observed is that the immigration judge always seems to be in a rush, a big rush. So the next way is a FOIA request. There's a broad request or a limited track 3, which is accelerated for the court. The key thing here is to be careful not to concede alienage when making the request. The case law is replete with examples where people have filed things and they've made concessions inadvertently in the documents that they filed. And then those things are considered to be tantamount to judicial admissions, and they come back to bite the people who filed them. And then, of course, there's the ORR non-FOIA request that's available for kids. Also, subpoenas. I personally love subpoenas. Subpoenas are wonderful. As far as the authority for subpoenas, it's 8 CFR 1003.35B. A subpoena can be issued by way of the immigration judge for the court itself, for the service, or for the client. It can require the attendance of witnesses or for the production of books, papers, and other documentary evidence. The key thing that you have to do that differs from district court as far as subpoenas is that for immigration court, there are conditions precedent to issuance, including stating in writing or at the proceeding what it is you expect to prove by such evidence that you're looking for, and also show affirmatively that a diligent effort has been made without success for you to get your hands on it without the assistance of the court. We recommend at least 3 attempts, because this isn't defined as far as what a diligent effort is, but we recommend at least 3 attempts or whatever the state substitute service diligence requirement is. I don't know what it is here in Texas. In California, it requires an attempt in person that doesn't work, and then you get to mail the documents if there's no response. That's for state service. But then there are federal requirements or federal guidelines for it also. But whatever the requirement is where you're practicing for reasonable diligence, meet it so that you can make that representation to the court that you have met it for whatever the state is. And then upon satisfaction of the requirements, and this is the best part, the immigration judge shall issue a subpoena, right? So it's not that the IJ may issue a subpoena, it's that the IJ shall issue the subpoena. They've got to do it. There's no discretion, it's mandatory, okay? Now, I ran across this case, and it's one of my favorites because in the opinion, it details all of the steps as well as all of the people and all of the documents and dates that were served during this case in terms of coming to the result. But the basic factual scenario is that 2 brothers were arrested in a workplace raid, and their lawyers got to work right away. In November of '99, they admitted service, denied the allegations, denied the charge of removability. In May of 2000, they moved to suppress all evidence and terminate all proceedings, and they did it on 3 grounds. Number 1, that the statements were obtained in violation of INS regulations and procedures. Number 2, that things were done in violation of the 5th Amendment guarantee of due process and no compelled self-incrimination. And number 3, that the evidence resulted from egregious conduct in violation of basic constitutional rights to fundamental fairness. So they took a 3-pronged approach. And then the next month, June of 2000, they sent a letter to the service requesting a tip sheet. Then there was the service refusing. And then September of 2000, they requested a subpoena for the tip sheet, as well as the INS agent in charge of the raid. Then what they did is in October of 2000, they requested a subpoena to a Georgetown law professor who was the former INS general counsel, who may have actually taken the stage today. And on the same date, submitted a brief in support of their motion to suppress and terminate, as well as exhibits and affidavits they intended to offer into evidence and a list of the witnesses they intended to call. And over the next several hearing dates, they engaged in the same pattern of an independent attempt, a request for a subpoena, and then advisement to the court of which witnesses were on tap and what they wanted to do with them. All the witnesses and evidence were allowed to be introduced that the counsel for the migrant wanted, and they won the case. And there's a long quote here from the court, which I won't read, but the most important part is that the court said that the proceedings have to be terminated. If this information is suppressed, which it was, proceedings must be terminated because there's no independent evidence supporting the allegations or removability. Okay, that was the result of a sustained campaign of requesting independently from the service, then requesting subpoenas, and then telling the judge what the subpoena would have been useful for, again and again and again and again. Again, the beauty of this case and this opinion is that the entire document list, witness list, and actions that the lawyers in that case engaged in are in the opinion, step by step by step. So it makes it easy to follow, easy to duplicate. It's a roadmap. So, investigation. Investigation is key. If you get your hands on at least some information, you want to, of course, get your hands on more information. A lot of times, in certain areas, there's a limited factual universe due to the fact that there are checkpoints, right? And so if there are checkpoints and people aren't tending to move beyond certain points, they're in a pretty well-defined geographical area, and a lot of the interactions that they have with people, a lot of the actions that they take happen within that geographical area. So if you can get a good investigator to do a thorough investigation within that geographical area, it should be faster than it would be if it were a bigger area, and also, if you're thinking about cost, cheaper. Investigation also preserves the advantage because it gets information for you that may not have necessarily come from the government. And if you think about, most of the more prominently covered cases in the news of all types, the biggest wins result from thorough investigation, right? I mean, whether it's Casey Anthony, O.J. Simpson, all the bigger wins, it's always thorough investigation. You actually out-investigate the government. So once you get a hold of this information, you want to really have a great opportunity to cross-examine and impeach. And of course, impeachment is merely a contradiction. There's no declaration of impeachment. Cross-examination is, of course, merely a series of well-planned contradictions on points that weaken the other side's case and or build your case, which then begs the question, why haven't you been having cross-examination opportunities? And when we were in Harlingen on a number of occasions, we think we figured it out, and that's because the government's witnesses are generally miserable, right? They as well as, I hate to say it, because I guess their colleagues on the other side, maybe not. The government's lawyers aren't that much better, right? So the government keeps its witnesses away from the proceedings so as to avoid exposing flaws in procedure, training, perception, memory, ability to communicate or comprehend, as well as bias, motive to fabricate. It all goes to credibility, trustworthiness, and reliability. Because they're able to, in many circumstances, simply rely on documents and reports, so they think, they keep the witnesses away. And why would you bring a witness to testify and expose all of that witness's flaws in perception and communication and everything else if you have a report that you can simply have the judge rely on without being challenged? You have nothing to lose by cross-examining the witness. Because if the government can rely on the report or would otherwise rely on the report and the court's gonna rubber stamp it, you have nothing to lose by trying to bring that witness in and attack them, cross-examine them, and undermine the foundation for what it is he or she has written in the report. Not a single thing. Olabanji, back to my favorite case, is a great basis for cross-examination. The court says that you get cross-examination unless the INS first establishes that despite reasonable efforts, it was unable to secure the presence of the witness at the hearing. So the question becomes, Have you ever seen a government lawyer for the service establish that they did a reasonable effort to do anything? You all have far more experiences with these cases than I do, but I gotta tell you, I haven't. And I haven't read about an INS lawyer establishing that they took reasonable efforts to do much. The other thing, matter of MAM, a BIA case, in addition, the act requires that an alien have a reasonable opportunity to examine and present evidence and to cross-examine witnesses, right? So it's there. You have that opportunity. And what does a cross-examination of a Border Patrol agent look like? I found this magnificent little video that actually shows it and is a great example of what it can look like if you actually can get one of these folks to come in.
When you're at the Border Patrol checkpoint, your duties are to enforce immigration laws and look for terrorists and look for weapons of mass destruction and assist in detecting narcotics. Is that correct?
Yes, sir.
And when you do this, of course, you're following a procedure manual that tells you what to do?
Following policy, sir.
Written policy?
Yes, sir.
You have a copy of that written policy?
No, I do not, sir.
Have you ever seen a copy of that written policy?
That states our authority to conduct immigration checks or for the checkpoint itself, sir?
For that checkpoint.
No, I have not, sir.
Are you aware of any written guidelines or policies or procedures on how to run that checkpoint?
I am aware that they're out there, sir.
You're aware that they're out there? Let me get this straight. You're testifying right now that you are aware that there are written guidelines and procedures for this checkpoint?
Can you state that question again, sir?
Is it your testimony here and now that there are written guidelines and procedures for this checkpoint?
To my knowledge, yes, sir.
Have you seen them?
No, I have not, sir.
But to your knowledge, they exist.
Yes, sir.
Do you recall on June 1st of this year giving a telephonic statement to Mr. Victor?
I do not recall the exact date, but yes, I do recall a telephonic interview, sir.
Do you recall you were in the room with Mr. Katz?
Yes, sir.
I believe there was another attorney in the room who was a representative of the Border Patrol Union?
Yes, sir.
And you were on the telephone to Mr. Victor?
Yes, sir.
And you're aware that that tape recording was being recorded?
Yes, sir.
And were you trying to tell the truth at that time?
Yes, sir.
Do you remember being asked during that statement if you were aware of any written guidelines, policies, and procedures for this checkpoint?
Do I remember that specific question, sir?
Yes, sir.
No, sir.
Do you remember saying that you were not aware of any written guidelines, policies, or procedures?
No, sir.
Would it help to refresh your memory if you heard a tape playing of your voice?
Yes, sir.
Your Honor, if I may.
If you want to use that one, it's fine.
It starts right at the beginning of that.
This thing needs to.
Please listen to this tape and tell me if this is your voice and if you remember being asked this question and given this answer.
And Your Honor, the state's going to object at this point. Was this noticed as part of your trial exhibit and disclosure?
Actually, Judge, this doesn't need to be noticed because it's impeachment, which is exactly how we're using it right now.
Your Honor, the same standard would apply to both parties. The state would expect that everything that be given in notice to both parties.
Judge, the law's well settled in Arizona. If the defense had to give impeachment to the state of the state's witnesses before the state's witnesses testified, it wouldn't be much of impeachment, would it? We're simply disclosing the audio tape of the interview that the state's witness, where the state's counsel was present throughout the entire interview.
Your Honor,
I have no understanding what possibly could be the objection to this.
Your Honor, may I have a moment?
You may.
Your Honor, Mr. Victor is quite correct under Rule 613B. The state withdraws its objection.
You may proceed.
Just ask this question. Do you have any written policies, procedures, or guidelines on how the operation of that particular checkpoint is to be conducted?
No, to my knowledge, no. There to determine citizenship, sir. If somebody's traveling through there, say, some sort of checkpoint, they're U.S. citizens, they're free to go. If they're not U.S. citizens, they say they are not.
Agent Gomez, did you recognize that as your voice?
Yes, sir.
Were you asked the question if there were any policies, procedures, or written policies, procedures, or guidelines for that checkpoint?
Yes, sir.
And was your answer that you were not aware of any?
Yes, sir.
Thank you. To have your testimony correct that when people pull up and you ask them if you're a U.S. citizen and whether they answer yes or no, then they're on their way?
Yes, sir.
So if someone pulls up and you say, are you a U.S. citizen, and they say no, they're on their way?
No, sir.
Well, which is it? You just said if they say yes or no, they're on their way. But then I asked the question a different way. If they said no and you said they're not on their way, which one is it?
Usually if somebody says no, they already have their immigration documents with them. They present that to me, and they're on their way.
And do I have your testimony correct that if you are unable to determine citizenship at the checkpoint, that you usually try to get them to go to secondary?
Yes, sir.
Not all the time?
No, sir.
So sometimes you cannot determine citizenship at the primary, but you just let them go?
No, sir.
Okay, now I'm confused again. I originally asked if you are unable to determine citizenship at the primary checkpoint, that you usually try to get them to secondary.
Yes, sir.
I did not say always try to get them to secondary. Do you understand my question?
Yes, sir.
Usually means sometimes not, doesn't it?
Yes, sir.
So is it fair to say that sometimes, if you are unable to determine citizenship at the primary checkpoint, that you let them go anyway?
No, sir.
I don't understand again. If someone comes up and you cannot determine citizenship, you say you usually try to get them to secondary. Is that correct?
Yes, sir.
Usually means not always. Is that correct?
Yes, sir.
Like, I usually wear a suit to court, but not always. Do you understand that?
Yes, sir.
So there are some times that people come up and you are unable to determine citizenship, but you just let them go on their way. Is that correct?
No, sir.
And what do you do with them?
I try to establish the citizenship there,
And suppose you can't.
and they go to secondary, sir.
So if you are unable to determine citizenship, they always go to secondary.
Yes, sir.
Not usually, but always now.
Yes, sir.
Mr. Anderson was sent to secondary inspection because of the dog alert. Is that correct?
It was a combination of both immigration and the canine alert, sir.
Okay. So you're saying part of the reason he was sent to secondary was immigration, not the
Yes.
dog alert?
Yes, sir.
But wasn't the decision made to send him to secondary, wasn't that decision made before he ever got to you?
Yes, sir.
And the decision was made, or you got the signal from Agent Spoonamore,
Correct.
before any immigration question was asked?
Correct.
And Agent Spoonemore gave you that signal because his dog alerted.
Correct.
So the dog decided to send him to secondary.
Correct.
How does the dog determine immigration status?
The canine does not determine citizenship, sir.
So he wasn't sent to secondary for immigration. He was sent to secondary because the dog alerted.
Mr. Anderson never answered my immigration question.
But the decision that he was going to secondary had already been made, correct?
Correct.
He could have pulled up to that primary checkpoint with a passport in his hand, and he was still going to secondary. Is that correct?
Correct.
Is there any better documentation of U.S. citizenship than a U.S. passport?
No, sir.
So it didn't matter what he said, he was going to secondary
Yes, sir.
because the dog said so.
Because the canine alerted to his vehicle, sir.
Is a canine trained to alert to people here illegally?
No, sir.
So the dog wasn't alerting for immigration.
Got to tell you, this is one of the greatest videos of anybody getting cross-examination that I've ever seen, or cross-examined that I've ever seen, because it's funny. I'll just basically detail to you what happens. So this Border Patrol officer is getting cross-examined on directing someone to secondary inspection, right? And so what has happened apparently is that someone came up to the checkpoint and, oh, wait a minute. Oh, no, okay. Someone came up to the checkpoint and did not answer his questions. And that person is the person in court that they're defending. And so they first cross-examine him on the procedures, the policies and procedures that govern how the checkpoint operates. And this Border Patrol officer, of course, has no idea exactly what the policies and procedures are that govern how the checkpoint operates. He does, however, know that there are policies and procedures that govern how the checkpoint operates because it's a government operation. So there's got to be some policies and procedures. But not only does he not know now what the policies and procedures were, and he can't tell the court what policies and procedures he used in order to direct the person to secondary inspection, he can't tell the court what policies and procedures he relied upon at the time that he directed the person to secondary inspection. So that's the first thing they go after him on. The other thing they go after him on is what exactly happened when he directed the person to secondary inspection. So the person ended up coming to him from somebody else, one of his colleagues, who had apparently given him the signal that that person was going to end up going to secondary inspection no matter what identification or questions or whatever the person answered when they got to him, the Border Patrol officer on the video. So they cross-examined him about that, just the fact that, it was already predetermined that he was going to secondary inspection. And so then the question came up as to how the predetermination was made that he was going to go to secondary inspection. And come to find out, he's going to secondary inspection because a dog alerted to his vehicle, right? And so the questioning proceeds, and what it does is first exclude immigration status from the determination, and then leave the determination that he's going to secondary inspection up to the alert, which then, of course, leaves that determination up to what? The dog, okay? And so what happens is that through this series of questioning, it's established that the dog is actually the person who decided that this guy was going to secondary inspection. And it's phenomenal. But I attached this video to show that oftentimes the people who fill out these declarations and follow these procedures and who engage in these procedures in these scenarios, they don't know exactly why they're doing what they're doing. And oftentimes, when they do what they do, the reasons why they're doing what they're doing are because it's always been done that way. And oftentimes, those ways that it's always been done are ridiculous. And that's what this examination shows. So just talking about the examination that we could see but weren't able to hear, but that hopefully I recounted pretty well. It was a cross-examination to establish an illegal search, illegal seizure, and an unfair and unreasonable procedure that, of course, flew in the face of all notions of fundamental fairness. It was a cross to establish flaws in officer credibility, and then the question becomes, would you believe a report from that officer is reliable? That officer who knew absolutely nothing about why he was doing what he was doing and actually conceded the fact that the dog made the determination for the person to go to secondary inspection. Generally not, right? And of course, then wouldn't the government's case be better if his report or affidavit came into evidence with the presumption of reliability and he stayed off the witness stand? Of course, the government's case would be better. And so that means that in order to make your case better, you got to get him on the witness stand. All right. That is the end of our presentation. I just want to say thank you all very much for having us. It was a heck of an honor to be invited to come and present this before you all. We are really, really, I guess I don't even know how to say it other than thankful for the work that you all do, because you're on the front lines of protecting really everything that makes America, America. You know, as long as there are families being separated and kids in cages, America's not America. It's almost like water's not wet and the sky isn't blue. And you guys are fighting against that. And to the extent there was even this little small presentation that we could do to help, we're very thankful. So thank you.
Professor Orange, we would like to recognize you with a scholar plaque. Thank you very much. And also to Yvette and Elisa, we thank you very much for your time.